Good afternoon. My name is Mary Meg McCarthy, and I'm the Executive Director of the National Immigrant Justice Center. And welcome to NIJC's Justice and Java presentation. We are excited about today's program, A New Era for Protecting the Rights to Asylum. And we look forward to discussing how our combined work of policy, litigation, and direct services are impacting our communities and our legal system. As you all know, there have been many changes in immigration law and policy in the last 4 years and most recently in the last few months. While some of you may have participated in our Policy Corner presentations, wherein we provided updates on a variety of changes, today we want to focus on our asylum system and how our nation responds to the most vulnerable individuals who are seeking protection. By the end of 2020, it was nearly impossible for many people who are fleeing persecution to seek safety in the United States. Access to asylum was closed, and those who were able to be in the country to apply for asylum faced serious obstacles to securing that. We are happy to see the new administration, but getting to justice continues to be a major challenge. It will take a long time for change to be implemented. And it's so important that we are all involved in pushing and moving and ensuring that individuals are able to access asylum. Many people forget that seeking asylum is a legal right. And we as lawyers, as advocates, as people who care about our country and about the right to asylum need to be involved in fighting for that access to be available. Some of the challenges are long-standing. Cases are delayed on the detention docket. It's even more difficult to secure fair adjudication of a case when the asylum seeker is locked up in a jail, which often results in that individual not having a clue as to what is happening in this process. Attorneys ensure that due process is available for all individuals. In this time of COVID, we're facing additional obstacles, and access to counsel is more critical than ever. As we transition to the Biden administration, we have seen many signs of hope, but we need to continue to push for meaningful change. In the next hour, my colleagues, Azadeh Afrani, who's a senior policy analyst based in Washington, D.C., Sarah Thompson, our litigation attorney, based in San Diego, and Lisa Coop, Associate Director of Legal Services from Indiana, will highlight how we are now continuing to protect access to asylum and ensuring that people are able to secure protection under our laws. We recognize that today we are 1 year from what dramatically changed our lives with COVID. We have learned a lot throughout this year, and one of those is how grateful we are for connecting with each one of you through these programs. We hope that you and your loved ones are healthy and safe, and we thank you for your continued efforts to ensure a humane and just immigration system. I will now turn it over to my colleague, Ellen Miller, NIJC's Pro Bono Manager, and we hope that at the end of today's presentation, you will become even more involved with NIJC. Thank you.
Thanks, Mary Meg. 1 year for sure. And so you are all most likely familiar with these webinar platforms, but before we go any further, to make sure everybody's on the same page, just a few considerations. One, we are recording this presentation, and the recording will be posted on our website and circulated in a follow-up email in the next couple days. Due to the number of participants, now, everybody is muted, okay? But we still want to hear from you. And so as you see, you might have seen my message already that please enter your questions and your comments as we go along the way today. We definitely want to hear from you. We have staff on board just to answer your questions. We'll have 10 to 15 minutes at the end of the presentation for Q&A. And if for some reason we don't get to it, we'll follow up in an email. So I think that's all for now. Let's continue. For those of you that this is your first time joining today, welcome. And we want to make sure that you know a little bit more about the National Immigrant Justice Center. NIJC is part of the Heartland Alliance, and we are headquartered in Chicago. We do have 5 offices across the country, including in Indiana, Washington, D.C., San Diego, and a presence in Texas. At NIJC, we employ an integral service model that works with high-impact federal litigation, zealous policy and advocacy work both at the national and local level, and high volumes of direct legal services. With our staff of over 125 wonderful individuals and our incredible network of almost 2,000 pro bono attorneys in 23 states across the United States, we have been able to provide services to more than 10,000 non-citizens during this difficult time. We are so grateful that you showed up today. We have a lot to talk about, so we're going to keep going. Today, to get us started, my colleague Azadeh will kick us off and tease out a little bit more about what we're already seeing with the Biden administration's approach to asylum. Sarah Thompson will talk to us and share a little bit more about the movement and some of the tensions going on in federal litigation, and especially will highlight these midnight regulations. You're then going to hear from a wonderful pro bono leader and pro bono attorney, Gretchen Wolf from Skadden, who will share some of her experiences as a pro bono attorney. And then last but certainly not least, Lisa Koop will provide details about how all of these changes are impacting and what our legal advocates and our clients and their families are doing to trudge through these challenging times and show their resiliency. Finally, we will provide a few ways that you can stay or get involved, because we know that none of this could happen without the community support, and then time for Q&A. We do recognize that you all showed up for a reason today, and you all come with your own experiences, and we want to hear about that too, despite these virtual platforms. So we'd like to take the next couple seconds and invite you to enter into the chat some of your hopes for the asylum system in the Biden administration, or some of your concerns that you already have about what could happen with the asylum system under the Biden administration. Please share with us now, and we will see what comes in now, and then we'll also be responding throughout the presentation. So let's see here. So if you have any hopes, concerns, or questions, we'd love to hear about it. We see a few coming in, and we see that Thomas here is hoping for a humane and welcoming system that's responsive to LGBT individuals. Great. More efficient processing. Okay, we'll be talking about that too. Establishing safe and efficient paths for asylum seekers. Great. Brenda, thanks for joining us. Jaime, great to see you again. Improvements for respect, language, and access. That's right. We have a great community today. Okay, we're talking about kids today as well, so thanks for joining us. Yep, hope is for fairness. We hear that, Adriana. Us too. So to get us started on some more content, while your hopes and your concerns and your questions come in, Azadeh, can I turn it over to you?
Absolutely. Hi, everyone. Thank you so much for joining us and for sharing these hopes and concerns. We have a lot to talk about, so let's dive right in. I wanted to start us off with some of the promising aspects and concerning aspects that we've seen from the Biden administration so far. As most of you know, the Trump administration has created an architecture of anti-asylum policies that have been really deadly, including forcing about 70,000 people to return to Mexico while they wait for their asylum hearings in the United States. President Biden took office and inherited this intentional chaos and has taken some positive steps ahead, but with some significant drawbacks. But let's start with the promising. What's promising right now is that finally, people who have been waiting for 2 years in dangerous conditions in Mexico are gaining entry to the United States. On February 2nd, President Biden mandated a review and the creation of a process for the orderly and safe admission of asylum seekers who have been stranded in Mexico under the Remain in Mexico program, or referred to as MPP as well. Since then, the Biden administration has worked with UNHCR to open up 3 ports of entry, and folks have been trickling in after 2 long years of waiting. Unfortunately, these admissions have been very slow, and there's been a lot of barriers for very vulnerable people to actually gain access to the United States. And we continue to be very concerned about the approximately 45,000 individuals who were summarily deported under that program and who would need redress. Because remember, this program is only affecting people who have active cases at this time. So people who weren't forced to give up, who weren't summarily deported before, during the manufactured crisis that we have, that the Trump administration created. So we'll hear a little bit more about this from Lisa in a moment, which basically turns us to the concerning developments. I'm going to breeze through the first 2 and concentrate a little bit more on the last. But to begin, expedited removal is a system where Border Patrol officers are both judges and executioners, and raise the bar for, and basically they process asylum seekers through fear-based screenings. However, those fear-based screenings have been very hard to pass under the Trump administration, resulting in countless summary removals. And the Trump administration also expanded expedited removal to cover a lot more individuals and a lot more geographic scope than the border itself. The good news is that the Biden administration is mandating another review of expedited removal and due process concerns. What's concerning is that they are also planning to ramp up its use, as far as we are hearing. And why this concerns us is that expedited processing is usually the enemy of due process, especially for traumatized asylum seekers. So we remain very concerned about a ramped up use of expedited processing in response to narratives of crisis and surge and whatnot with respect to the border, when in fact it's just asylum seekers who are coming to, as many of you have said, lawfully ask for asylum. The second thing that's concerning is that ICE has issued a memo of enforcement priorities, which flies in the face of asylum rights. There's many problems with it, including continuing to criminalize immigrants in the United States and maintain the pipeline between interactions with the police and interactions with ICE. But at the same time, they have labeled anyone who entered post-November 2020 a border security priority. So let that sink in. That means that there is a lot of concerns that essentially asylum seekers are going to be viewed as an enforcement priority under this new memorandum, and trampling again the right to seek asylum under U.S. law. The last thing I want to talk about and spend a little bit more time on is the use of expulsions, which started under the Trump administration about a year ago on March 20th. So with the COVID-19 pandemic, the Trump administration had really seized an opportunity to weaponize public health in terms of closing the border and shutting out asylum seekers. So they basically created a new track, a new deportation track where asylum seekers are speedily returned either to Mexico or to their country of origin. And it has impacted an extraordinary amount of people, about 500,000 to date. So in the next slide, we're going to talk about this a little bit more in detail. So what you see in this at the bottom, at the top right of this chart is really truly breathtaking. In the red columns that you see are asylum processing. So on average, before this pandemic began, we had about 32,000 individuals coming at the border and processed because they were seeking asylum. That plummeted by April 2020 to a little over 1,000. On the other hand, you see that this new expulsion track, right? This new way of basically deporting people speedily started from 0 in March of 2020 and became about 60,000 a month and counting, even under the Biden administration. So far from ending these expulsions, the Biden administration has now said twice that they plan to expel the vast majority of people at the border using these Trump-era expulsions. Now, this again flies in the face of public health and epidemiology. The community of experts have found no basis for doing this. There is no reasoning that asylum seekers pose a threat to the public health of the United States. And of course, there's an inherently racist history that this conjures up, because here we are equating migration, equating those who are seeking refuge with spreading disease, as if, again, asylum seekers were the crisis. If you take a moment to think about that, asylum seekers have very little choice, because otherwise, why would they come to the world's hotspot with COVID-19 infections with 500,000 deaths? They don't come because they want to, they come because they have to. And the real crisis is not with them, but with the US government's response and in scapegoating them in the name of public health. And unfortunately, this isn't the first time that the US has done that. The same thing happened with the HIV crisis, where basically the epidemic was used to deport asylum seekers and push them back unlawfully, primarily asylum seekers coming from Haiti, because the government was tapping into the fears of the public that they were going to see an increase in infection rates. And here again, we're seeing a disproportionate impact on Black and Brown asylum seekers, including Haitians, including really heartbreaking stories of asylum seekers who are coming to the border with lots of evidence at hand that they were tortured, only to be returned back to the very conditions that they have fled. So I just want to close by sharing that we're going to send you a new material, frequently asked questions, that we're releasing later today. So please keep an eye out for that. We continue to advocate that the Biden-Harris administration has to end these expulsions in order to protect the right for asylum, and that there is more than enough evidence that, you know, public health, it does not demand an end to asylum, far from it, and that there are sound ways to do both end, to protect public health and protect the right to asylum, which is what the administration should do. So I'm going to close here and turn it over to Sarah, who's going to walk us through some of the concerning developments from the regulatory and litigation side.
Thanks so much, Azadeh, and thank you to everyone for being here. I apologize, because this is how these things work. I have lawn mowing on one side and construction on the other right now, so apologies for that disruption. But my name is Sarah Thompson. My pronouns are she, hers, and I'm going to talk a little about what we call the midnight regulations. Not much has changed yet for the litigation team. We're still working really hard on cases challenging a lot of Trump-era policies. So the midnight regulations are a group of regulations that the Trump administration published in mid-December 2020. This was about, 6 or 7 very lengthy regulations with thousands of pages that were all slated to take effect the week before inauguration as a last-ditch effort to really, eviscerate due process in our immigration system. And, for context here also, this was mid-December. We were all kind of winding down after a tough year, looking forward to the holidays as a respite. And this all came at us at once. And we really think that this was part of a tactic, a conscious tactic by the Trump administration to of overwhelm and to sneak as much as possible under the radar at the very last minute. A lot of these regulations were labeled as procedural, but actually have very significant substantive effects on the right to seek asylum. So at that time, we circled up with other organizations nationally to try to figure out what we could do to stop these regulations from taking effect. And NIJC was able to take on 2 of the regulations that no other organization had capacity to challenge. And so in January 2021, just a couple months ago, we filed 2 lawsuits challenging 2 of these regulations after, really going into crunch time and working hard over the holidays. So I'm going to talk about one in particular called the Asylum Procedures Rule. Again, which is labeled procedural, but really, as I'll explain, has really large potential impacts on the system. And I want to differentiate this one from what some people call the mega rule, which is another huge rule that changed the eligibility requirements for asylum. Many of you on this webinar may have submitted comments on that rule, but this is a completely separate one, which I think really illustrates sort of how complicated and intertwined all of these new regulations were, which made it even more difficult to bring these challenges. So this rule had 6 main parts. The first part was imposing a 15-day deadline for people to submit in removal proceedings to submit their asylum applications. And, everything has to be in English. And I think it's not hard to see why, with evidence even in English, and I don't think I have to explain why this is really difficult, if not impossible for many people, especially who don't have lawyers. A next aspect of this rule was to require proof of payment. Of course, this is financially, this was in conjunction with another new regulation that imposed fees on asylum applications for the first time. Luckily, that has been the right to seek asylum should be someone's income. Alan, can you go back one slide? Thank you. Someone's ability to seek asylum should not be tied to their family income. And also this was logistically difficult, especially for people in MPP that didn't have fixed addresses. Part was a rejection, a blanket rule to reject what they called incomplete applications, which were really applications that left any space blank. Now, this was incorporating a policy that was first implemented at USCIS, which is a different agency that adjudicates visa applications. But this would require everything to be filled out, even things that were clearly inapplicable to someone's case, like children's names if they didn't have kids, for example. And instead of leaving them blank, you had to write not applicable. And again, especially for people with language barriers, that was really difficult. Next, it would allow judges to act as advocates, to submit their own evidence into the record, and especially after what we've seen with the politics of immigration judges being implemented, we think that would really prejudice asylum seekers. There also was a new provision that would give undue weight to all US federal government authored sources. Written by the same federal government who's the opposing party in these cases, who's trying to deport these asylum seekers. So many of you on this webinar who are part of our pro bono network may have heard about the State Department reports, for example, it's been well documented that these State Department reports have been authored over the last few years to get rid of provisions that might be helpful to asylum seekers. And so this would allow judges to give far more weight to that kind of thing, and not give weight to publications by other reputable agencies like the UN or any NGOs. Now last, this would require a 180-day timeline to resolve asylum cases. In some way, this is good because we all want the backlog to be gone and we want our clients to get their cases resolved and be out of limbo. However, this was a really strict, inflexible time frame that wouldn't work for a lot of our clients. For example, some people who have gone through extreme amounts of trauma take a while to open up to their attorneys, and that delays our ability to present their case properly. It also, some people speak pretty uncommon languages, and so it takes a while to find interpreters, and there's any number of reasons that strict timeline wouldn't work. So to summarize, these were much more than kind of dry procedural changes, and would really effectively eviscerate our asylum system. So luckily, we were able, in partnership with Jones Day and with co-plaintiffs, IMDEF, the Florence Project, and Las Americas, which are all legal service providers on the border, just as we are, we were able to get this rule enjoined, which just means that it was stopped one day before it was supposed to take effect, which was really fantastic. And originally we were cautiously optimistic about this because we thought maybe this would be one of the regulations that the Biden administration would review and perhaps get rid of. But unfortunately, we were really disappointed that just yesterday they filed an appeal of that decision, and noticed their intent to keep fighting us aggressively on this rule. And so it's a good reminder that these harmful policies did not begin or end with Trump, and so we're going to have to keep on fighting them through this administration. So now, before handing it back to Ellen, I just want to emphasize that this type of litigation is a collaborative process that's only possible because of the different people doing different interdisciplinary work at NIJC. The policy team and Azadeh did amazing work writing comments on these rules and doing the preliminary analysis, and then Lisa and our direct services team helped us write declarations and really go through the practical impact on our clients. And so this was really a team effort within NIJC. So thank you. With that, back to Ellen.
Thanks, Sarah. I wish it didn't have to be so difficult. But like you said, a lot of effort by a lot of people, and we can get this done. So now we've heard about changes in policy and some aggressive litigation efforts, and we've started to hear about how all of these changes are causing a real tizzy in the legal community and with the clients that have to work through it. So our next speaker is a litigation partner and leader at Skadden, Arps, Slate, Mager, and Flum in their Chicago office. She is also a dedicated pro bono attorney. And Gretchen Wolf has worked on a number of NIJC matters, including citizenship, VAWA, and asylum. She recently led a team that won asylum with a client from Guatemala in January. And so she's thus navigated all of these changes in laws, policy, and with the COVID considerations. She will now share a bit of her experiences as a pro bono attorney.
Hi, my name is Gretchen Wolf, and I'm a litigation partner at Skadden's Chicago office. I took my first pro bono asylum case with an NIJC client about 16 years ago, and I've been working with NIJC and assisting their pro bono clients on a number of matters ever since. And while every case and every client presents their own challenges and opportunities and learning experiences, Representing a family in their asylum proceedings over the last couple of years, and especially over the last year, has been especially challenging and rewarding for me. Despite the environment and the fact that folks were working remotely and dealing with all kinds of their own sort of personal challenges, not to mention an overwhelming need that all of the NIJC staff are trying to meet, I found that they were so responsive, so helpful, provided such relevant and perfect guidance, not only on the legal issues and the ever-changing law, but also just the practical things about how to navigate the new rules and procedures of the courts, and ways to to break through some of the logjam in the process that is already complicated to navigate. I also found that although it was a challenging time, it actually provided some opportunities to connect with clients and assist them in ways we had never really explored before. I had always met in person with my clients and tried to get all the papers signed in person and deal with everything in the old-fashioned way. But with the procedures relaxed a bit, and really, frankly, all of us being forced to find new ways to communicate and connect, I found myself relying on text messages and Google Translate and FaceTime and all kinds of ways to bridge that communication gap, prepare for our hearing, work with experts, work with translators, and serve our clients. And with the team of associates who helped me, we found that that long and winding path was so worth it when we were able to sit with our clients in December and hear the immigration court judge grant them asylum after their long and winding path. And I couldn't thank the NIJC team more for the help they provided and the opportunity they gave to us. And I would encourage anyone who's considering this to take on an asylum case. Don't do it alone. Pair up with your colleagues, put together a team. It's a great way to connect. It's a great way to support each other and learn some new things. And it is so rewarding that you will continue to come back again and again to help and to learn and to grow as a lawyer, as an advocate. Thank you.
Okay, so now we've heard from our wonderful part of our wonderful pro bono network and how all of these pieces are coming together. I'm going to turn it over to Lisa now as we wind up the content here, and we love all the questions that are coming in, so please keep them coming. And let's hear a little bit more about how our advocates and our clients are responding with all of this. Thanks, Lisa.
Sure, thanks, Ellen. Looking at the list of participants here, this is a little bit of a daunting crowd to speak to, and I regret that we're all remote and can't be having this conversation in person. I know there are current and former UNHCR folks, people who've worked as asylum officers, current and former NIJC colleagues, community partners, and many of our pro bono partners, like Gretchen, who make these life-changing interventions on behalf of our clients. So please do drop questions and comments into the chat, share your expertise. We all benefit from our collective knowledge and experience. My name is Lisa Coop. I work out of NIJC's office in Northern Indiana and do a lot of work with our direct services projects, providing asylum representation both throughout the Midwest and over the course of the last 2 years, down along the US-Mexico border in Laredo, Texas, where we've represented initially separated families. So we worked with a lot of mothers who were in ICE detention after their children were taken from them, and they were held in jail and forced to litigate their asylum claims from detention. And then we pivoted in September of 2019, along with our pro bono partners, Jones Day, to respond to the migrant protection protocols, the Remain in Mexico program that cropped up right across the border in Nuevo Laredo, Mexico, where there weren't other legal service providers. And we were proud to be able to partner with Jones Day to fill that gap and respond and hopefully meet the need of a small slice of the individuals in MPP. But I wanted to take this opportunity to talk a little bit about how these policies and litigation efforts and ongoing government efforts to impose those awful regulations land on the shoulders of our clients. And before you see maybe just a little window of hope of some of our clients that have won asylum, all of them within just over the last year, actually. That young woman with the baby there, she'll reach her 1 year anniversary of winning asylum in Chicago this week on March 12th, 2020. That was one of the last days the Chicago immigration courts were open. You'll see we're not wearing masks. We were in court. We were conducting hearings and you know, starting to figure out like, oh, COVID might be changing the world around us, but managed to get into court. And our law student, Narita Lopez, won asylum for her. And so, you know, to see these lives that are changed when people are able to meaningfully access safety and protection and stabilize themselves and their families is no small thing. And so figuring out how we do that as we transition out of a Trump era where there was just an onslaught of constant regulations, attorney general decisions, really tough immigration judges coming onto the bench that were really determined to find ways to deny our cases. You know, how do we continue that work as we transition into a Biden administration where not all of that goes away immediately? You know, Sarah talked about our hope that we could sort of begin to breathe and relax a little bit as we moved into the end of last year, only to be met with those regulations and a really tangled and complicated wind down of migrant protection protocols and the ongoing effect of Title 42, that sealing of the border, that prevention of asylum seekers from exercising their human rights to be allowed to come and seek asylum. So what does that look like for our clients? How do we help them? How do we come together as an advocacy community and conduct advocacy on behalf of them? I think those are the big questions of our day. You'll see that middle picture there, two other, again, these are all my Notre Dame law students. I teach the externship program through at Notre Dame Law School with through which these law students handle NIJC cases and just do incredible work. And you'll see there two of our law students wearing their masks who had just finished conducting a socially distanced asylum trial in the Chicago Immigration Court. That was last October, and they won asylum for their client, a young woman from Central America, despite all of these odds. And so just to kind of reiterate Gretchen's message that this involvement where we can intervene, where we can be the lawyers and provide support for asylum seekers, it does make a difference. We just want to move towards a system where it doesn't take a law school or a law firm or, you know, hundreds of attorney hours for people to be able to access protection. And so how we think through the policies, the regulations, the changes in laws to better extend these protections, I think is a really important question. So we can go to the next slide, and it's again, you know, sort of a good news, bad news scenario where we're looking at a reduction in detention. Will we see the Biden administration, for example, end contracts with private prisons? Can they be convinced to finally meaningfully reduce the use of ICE detention to put in jail asylum seekers and other immigrants who are forced to be separated from their families and their communities and try to access due process from detention? We saw in one case, you'll see it's a little bit small on the slide there, but there's a tweet from Ayanna Presley and one of her staffers who got involved in one of our cases that if you've come to Justice in Java before, you've maybe heard us talk about our client, Mariana, who was an Angolan woman who came to the United States just about 2 years ago with her children and was separated from them at the border. They were briefly in a family detention center in Texas before the government took her children from her and sent her to an ICE jail down in Laredo and sent her children into the Office of Refugee Resettlement custody system, where we met them in Chicago. And for 2 years, they were separated and Mariana was in jail, and she fought for asylum before an immigration judge that has an incredibly high asylum denial rate. And we were denied asylum. We were able to go to Texas and represent her, and she was denied asylum. And then COVID hit, and with pro bono partners from Barnes and Thornburg, we filed 2 habeas petitions to try and get her out of jail and failed both times. The first time we filed a petition, the government moved her to a different jail to strip jurisdiction from the judge who had drawn our case. And so we filed a second habeas petition, which was also denied. And poor Mariana sat in detention. She contracted hepatitis B, and so was medically vulnerable during COVID, and nonetheless the government refused to release her. And so when the new era dawned and we moved into the Biden administration, we were hopeful that we could finally get her out of detention. And she was one of the people that was nearly deported by rogue ICE officers who, even after the Biden administration attempted to instate a moratorium on deportation, tried to hustle a whole plane load of people to the middle of Louisiana to fly them off to largely West African countries in that case. And thankfully, our policy team and our direct services team partnered together, and we managed to gain the interest of Representatives Ayanna Pressley and Jan Schakowsky, and they got on the phone with the ICE director, and we managed to get Mariana's deportation stopped, and ultimately she was released from detention a few weeks later. She still has a long way to go. Her case is still on appeal. We haven't won asylum, we haven't won protection for her yet, but we're grateful that she's out of detention and hopefully moving towards a more stable life and more meaningful safety. By the same token, we're happy for the wind down of the migrant protection protocols of that Remain in Mexico program, which the picture down there, those are actually the tent facilities that were built just north of the Rio Grande in Laredo, Texas, where we've, along with, again, pro bono partners from Jones Day, tried to represent clients who have appeared in those courts and tried to seek asylum while remaining in Mexico, subject to all kinds of harm in Mexico. So we're beginning to see some of our clients be registered through the UNHCR's portal in order for them to be allowed to come in the United States. There are a lot of difficulties in that system through no fault of the UNHCR. They've really stepped in. So again, that's United Nations High Commissioner for Refugees has really stepped into this void where there was a need for someone to play a coordinating role to try and register all of the people who were in MPP and plan for them, screen them, coordinate their entrance into the United States. Right now, our clients aren't actually entering because they're mostly in and around Nuevo Laredo, and it's not safe for them to travel to one of the open ports of entry. So one of our big asks right now is that the government go ahead and reopen additional ports of entry so that all of the asylum seekers who are in MPP can be allowed to enter the United States and don't have to undertake additional dangers by traveling over to Juarez or over to Matamoros in order to try and come into the United States. Meanwhile, in the Midwest where I sit, we're already seeing the fallout of MPP cases, not only in our own clients for whom we initiated representation while they were in Mexico, but for people that have managed to enter the United States despite MPP. So we're seeing, for example, children show up in the Office of Refugee Resettlement Shelters, where we're the legal service provider, who were previously in MPP. And it seems likely that their parents made the excruciating decision to send the children ahead. So they were in MPP with their families and subsequently entered the United States on their own and were taken into the federal custody system there. A lot of them have prior deportation orders. These are children who have removal orders and are in need of getting those cases reopened so that they can pursue their claims and hopefully be reunified with their families down the line and able to seek protection. Again, this is a space where the government could be doing more. The government could say, we're going to, make every effort to rescind removal orders where an unaccompanied minor shows up having previously been in MPP. We haven't seen that yet, and we're hopeful that that's progress we can see made among the government. And we'll talk in a moment about other clients that we're seeing who've been through MPP, who arrive in our communities and are contending with the severe trauma that caused them to flee their countries in the first place, and then the additional layers of challenge that they experienced while they were in MPP. And how do we begin to untangle those cases and position them so they can seek asylum? I think that'll be an ongoing challenge for years to come as those cases move forward in the system. Azadeh already briefed you on Title 42 and the ongoing challenges and COVID-19, the court backlogs. I mean, those things all work in tandem. So even as we're getting cases that are moving forward in the system, at least in the Chicago courts, and I know in courts nationwide, these backlogs are going to result in extremely long waits for ultimate adjudication of asylum claims for years to come. In Chicago, we're in at least late 2023, if not 2024, for court dates to have trials, to have these asylum cases heard. So when we're getting involved in these cases, this isn't something where it's going to be a 2, 4, 6 month turnaround. This is something where we're going to be working on these cases for years to come, and these clients, these families are going to be in need of community support and legal services support. And we'll continue to deal with the Attorney General decisions and hostile courts. So Attorney General Jeff Sessions, just to name one of the really terrible Attorney General decisions that will continue to have to navigate around, matter of AB, which was the Attorney General precedent decision that tries to assert that people who are fleeing gender violence, people who are fleeing gang violence in Central America won't be eligible for asylum. Now, any of you who are pro bono attorneys with NIJC know that we argue vigorously that that is not the proper interpretation of that case, and certainly not in the Seventh Circuit, where our particular social group test is very different from the one announced in matter of AB. But nonetheless, it sent a very clear signal to immigration judges nationwide that they should be looking for ways to deny cases rather than examining cases to seek the just outcome, and recognizing people who meet that refugee definition should be granted asylum. So if we go to the next slide, we can pause for a moment and maybe take a closer look at how this plays out in the lives of our clients. And Ellen will get us back to the slide in a moment that shows our client Paula, who is a woman who was in the migrant protection protocol. So as a child and then as an adult, she experienced egregious gender violence in her country of origin in Central America, and ultimately fled to the United States within the last year or so, actually about 2 years ago at this point, and presented herself at the border. And as with everybody who was placed into the migrant protection protocols, presented herself at the border and was turned right around and told, okay, if you want to apply for asylum, you know, here's your tear sheet, here's this ambiguous document that purports to give you instructions about how to seek asylum. Go fend for yourself, figure out a way to survive in Mexico, and show up back at the bridge in a couple of months in order to pursue your claim, and figure out how, as a pro se litigant, you fill out this asylum application in English and present it and gather evidence and present your case before an immigration court. And while she was an MPP, like so many of our clients who we've represented, in Mexico, she was kidnapped by cartels and likely by Mexican government officials, and she was assaulted by her kidnappers and ultimately released, but not after having experienced pretty incredible harm. So she made her way back to the border and was initially told, oh, you're lying, all of you are lying, everybody, you know, claims that they were kidnapped, everybody claims that they were assaulted. But she somehow managed, and this remains mysterious to us, managed to achieve a non-refoulement, or no refoulement for the French speakers out there who can probably pronounce that far better than I can. But she managed to succeed in one of those screening interviews and establish that she would face harm in Mexico, and so was allowed to come into the United States. And this, I need to emphasize, is an incredibly rare situation where somebody was allowed out of MPP and allowed into the United States on parole because they faced harm in Mexico. She was given an ankle monitor, so you know, even though she was in no way a flight risk or a danger to the community, she was given an ankle shackle and allowed to come into the interior of the United States. So she made her way to Indiana, where we met her and learned about her case and began representation. Realized that she was had missed her 1-year filing deadline. I saw in the comments, like, can't we just for once and for all get rid of that 1-year filing deadline, which is this arbitrary rule that if you're going to seek asylum, you've got to do it within a year of arriving in the United States, and if you don't, then you may not be eligible. And she's subject to that 1-year filing deadline despite having been placed in MPP, and so we'll need to argue that she's, you know, meets one of the exceptions to the filing deadline. She's currently scheduled for court in San Antonio in April, so next month she's supposed to appear for a hearing. She's obviously now living in Indiana, and so she'll need a change of venue. We filed her asylum application for her with an argument. So Mendez Rojas refers to a class action lawsuit that gives us an argument around that 1-year filing deadline. But it's a little bit of a complicated process, and certainly something that would be difficult for somebody without an attorney to be able to assert. But we filed her asylum application. We made this argument around the 1-year filing deadline. We filed her motion to change venue. and are working to position her case really to just get to the starting line of the asylum process. All of this has to happen before she even meaningfully begins the process of presenting her case in immigration court. And so once we get all of that squared away and hopefully convince that court in San Antonio to change her venue up to Chicago and give us a little bit more time, then you'll probably be seeing her on our pro bono list, because she will be one of the many cases sitting on our pro bono list waiting for representation of an attorney. Because right now it's not possible to win a case without the involvement of counsel in most cases. And so the role of legal services is really critical in making sure that these cases can be untangled and positioned for success. So at present, there are 48 asylum matters on our pro bono case list. And I know there are a lot of current and former NIJC attorney, pro bono attorneys on this call, and future pro bono attorneys. So I would invite you to be in touch with us if this is a space where you can envision getting involved and interceding on behalf of asylum seekers like Paula and like others that are, hopefully coming in from MPP. Hopefully in the near future, people that have been kept out under Title 42 will be arriving in our communities, and they'll need intensive support and legal services. On top of that, we talked about those midnight regulations. Between November and early January, we filed 136 asylum applications because we were so concerned that if those regulations went into force, they would so severely prejudice eligibility for so many of the asylum seekers with whom we had contact that we really prioritized getting those applications completed and filed to preserve their eligibility, which we're happy to have been able to do. That now means there are 136 additional asylum cases moving forward that will need counsel and will need representation. So we are very eager to continue our partnerships with pro bono law firms, with others who are interested in getting involved in this work and partnering with us to try and achieve justice on behalf of these asylum seeking families. So with that, I'll turn it over to Ellen to talk to you about some other concrete steps. And we'll take a look at these questions that I've been hearing dinging in that will, I think, guide the rest of our conversation together.
Thanks, Lisa. A lot going on. So as we wrap up here, we definitely want to leave some time for your questions. And I know that our team is responding to them as much as possible in the back. But if anything, I think these comments today and the information we shared have shown, the opportunity, if nothing else, the opportunity to show how resilient our community is and our clients are, and that we will keep fighting for this justice. And so we are grateful for, and we ask for your continued support, and there's different ways that you can do this. One you already did today because you showed up and you have this information. So we ask you to stay informed and spread the word. You can visit our website for more updates. If you are an attorney, please, we invite you to check out our case list and talk to some colleagues and see if you can represent a case. If you have language, if you are rather fluent in a specific language, we always need volunteer languages services for interpreters or translators, particularly French from various African countries, Arabic from various Middle Eastern or Northern African countries as well. And if anybody knows sign language, we are in need of some sign language interpreters as well, as much as that can be translated across the various continents as too. As a nonprofit, we definitely appreciate your financial support and donations if you're able to do so. And I think one of the most important things we can do through all of this, and as you've seen, is be an active member in our democracy and stay involved, communicate with your members of Congress, communicate with your neighbors, share with them how these stories are impacting you, how your stories are impacting, in your community. So please stay involved. Please tell your members of Congress what is important to you, and so that we can see some of these changes legislatively or in policy. Okay, finally, before we just have a few minutes left for Q&A, if you hold up your device here, we definitely appreciate your feedback. We sincerely take it into consideration as we plan these next presentations. Hold up your device and answer that 4 to 5 question survey. Otherwise, we'll send you the link in a follow-up email with the recording. We do have more presentations coming up on April 6th. Our policy team will come back for some highlights on local policy issues, and we have other trainings and events coming up you can check out on our events calendar. And so without further ado, I am going to jump into some questions here. I know that the team has been furiously typing in the background. And I'm wondering if Sarah, Azadeh, and Lisa, you could turn your webcams back on. And we're gonna just kind of talk about detention and EAD in the first few minutes, and we'll see what else we have time for. So Sarah and Lisa, Azadeh, there were some questions about detention and folks remaining in detention through all of these, and kind of what are we hoping for the detention process. Would one of you be able to respond on our work with detention right now?
Sure, I can take that. I mean, I think, NIJC's position is that there is rarely, if ever, a reason why a non-citizen should be held in immigration detention. And so we are, very much pushing the government to not only stop detaining non-citizens, and as I mentioned before, certainly stop contracting with private prisons to profit off of the detention of non-citizens, but also to reduce the use of things like ankle monitors, like ankle shackles, like our client Paolo was on, that are restraints on liberty that compromise the dignity of our clients, and at bottom are completely unjustifiable and unnecessary, and completely inappropriate to be applying in the context of immigration proceedings. So I think we will continue to push very hard, both in the context of appropriations. Congress shouldn't be funding the use of, beds in jails and detention centers and so forth, and just continuing to argue that immigration detention is not appropriate in any case, and certainly is, by definition violates the due process rights of non-citizens in proceedings.
Thanks, Lisa. We also see a lot of questions here before we get onto some EAD issues. We see a lot of questions about whether the US government is doing anything to find or locate or support people in Mexico. And with this, frankly, human-created humanitarian disaster of MPP. Sarah or Azadeh, do you guys want to comment a little bit on what's going on or not going on?
Yeah, I can talk a little bit about the situation here in San Diego. So the MPP program, as we already discussed, is winding down. And so some people are being admitted from that program, but there is still a really big backlog at the ports of entry here. And the government is still not admitting a lot of people who have been what's called metered, which means they've just been forced to wait in a line to even kind of initiate the process of seeking asylum, or others that have just not had access for a variety of reasons. So we're hoping that there is some progress, but we're hoping that they will start doing a lot more.
Yeah, and I would just add, this is a space where we really do want to see the government step up. Right now it's civil society, it's UNHCR, it's HIAS, it's KIND, it's a lot of partner organizations that are on the ground doing the work to try and identify people that have been through MPP. We're still in what they're calling phase 1, which means people that have active cases in MPP are eligible to apply for this parole, but that doesn't speak to what happens to the tens of thousands of people that were ordered deported because they couldn't make it to their court hearings because they were kidnapped at the time, or because they had to leave because they couldn't tolerate living in MPP. So there is a very real need for concrete action to happen. Obviously, the government has a list of everybody who's ever been in MPP because they registered them all in MPP. So there is work that can and should be done to identify those families, and there's remedial actions that we need to see taken. It may be that we need to have an easier path to motions to reopen, or examination of immigration judge decisions that have been made during MPP in order to make those families whole and give them a real opportunity to seek protection and seek asylum.
Okay, I would love to ask these questions about employment authorization for asylum seekers, what's going on with the backlog of court cases and hiring of judges and replacing some people that were appointed during the Trump time. Unfortunately, though, I know that everybody is busy and that we are out of time. So I encourage everybody to stay in touch, keep updated with the materials that these wonderful teams are putting out on our website. Like Azadeh said, a new FAQ will come out today on the expulsions. So stay in touch, reach out. Lisa, Sarah, Azadeh, you are always inspiring, and so thanks for your words today. And with that, we will sign off and see you at our next presentation. Bye. Thank you.
Bye, everyone.